Welcome to LexTalk World Talk Show presented by Clickaway Creators. Today we have CS Rahul Jain with us. Rahul Jain is a qualified company secretary, a certified trademark agent from IP India, and an alumnus of the ISB Hyderabad. He co-founded RANJ, a multidisciplinary firm offering a range of one-stop solutions in the sphere of corporate laws, intellectual property rights, insolvency laws, security laws, Forex regulations. Rahul has implemented comprehensive compliance management programs for top listed and unlisted public companies by leveraging technology by thereby ensuring enhanced IP protection and corporate governance practices. As a professional negotiator for commercial contracts, Rahul has been instrumental for enforcing many cross-border business transactions for large companies engaged in pharma, technology, and infrastructure sectors. Hello, Rahul. Thank you for joining us.
Hi, Raima. Thank you for your wonderful introduction. And I'm really happy that I could make it for this interview. Thank you so much for this opportunity.
The pleasure is all ours, Rahul. Thank you for joining us today. And how are you feeling? How is your feeling after the conference?
It is amazing. I think the kind of post-award responses that I have been getting from the clients, from the professional fraternity, from the family and friends, it is overwhelming. This is something like a milestone for us after a decade of more than a decade of service. I think this is an achievement which I would cherish forever.
We are so glad to hear that, and we are glad to have you today in this interview. Without any further ado, let's start with the first question of the session. So, first of all, we would like to know how, about a complex legal issue you have worked on, and also describe the complexity and tell us how you have approached it.
Sure. So this Lex Falcon Global Awards that we have been bestowed with is under the category of 10 plus years of practice in intellectual property rights. And I would like to share one such scenario relating to a trademark litigation or a forceful change of a trademark of a company. So it is like under Companies Act, there is a section 16 which says, which allows any company or any applicant to file an application with the Regional Directorate of Ministry of Corporate Affairs, India, to force change any other company's name if it is a case of trademark infringement. So one such company, MNC company, had filed one application with one of the regional directorates in Ministry of Corporate Affairs, forcing or mandating the rectification of name of our client company, alleging that their the name that they had is what our client company has adopted, and with deliberate intent to catch upon the fame or name of the MNC company. The contentions were very, very harsh on our client, like that we have deliberately chosen or similar name, deliberately chosen similar to their name, and wanted to gain business or revenue out of it. They alleged that they were a well-known trademark, and as such, even remotely similar, if not identical mark, also would require us to forcefully change our name through the order of regional directorate. And because of this pressure, prior to this litigation, our client, though I was not involved in that litigation process, are already withdrawn the trademark application that they had filed for the same name. So they have ceded to the pressure earlier. But when it came to me, I said, no, I'm not going to take this hands down. And I think I'll put a tough fight against this frivolous application which the MNC company has filed. So it's about more than 160 countries that this MNC is registered and doing business, and they have trademarks all over the world. And that is pitched against a company which is hardly known in India, but they were into completely different business, and still we had to face this. So we obviously made our submissions. The complexity was that we had to prove that their application was illegally filed or not within the law. So one, it was time barred, that we have to prove that they have elapsed the 3 years time period that was allowed under Section 16 of the Companies Act to file such kind of a trademark rectification name. And also that they had made a very big blunder is they've authorized their attorney to file a physical application, which, a lot of, because I'm a company secretary in practice, so that gave me an added advantage. The point that is, now there are no filings allowed under Companies Act physically, and even at that point of time, and they had made that blunder of filing it, physically. So on that technical ground alone, their application was liable to be rejected. And obviously, they said that they're well-known trademark, which I had proven through various case studies, judicial pronouncements, that they were not a well-known trademark. They were falsely claiming to be a well-known company or a brand globally. Although we are not denying what they achieved, but the point that is that the grounds on which they made an application were a little too high, or too much to ask for against regulator, a regional directorate, which is not an out-and-out trademark related regulator. Okay, so obviously our client withdrew the application in the trademark registry, but then here we put a tough fight, and the result is the order was in our favor. Although the other company was a sizable company, they had operations all over the world, and our client was not so biggie, but then a little bit out of the box thinking, getting into the technicalities of law as well, worked in our favor. And that's very complex scenario that we faced, and obviously we had other situations, typical situations as well, but this is something which was recent and closer to me. So I think people should know about this.
Thank you, Rahul. Thank you so much for sharing the incident beautifully. And then, followed by that, we would like to know that the pandemic saw some courts begin moving towards more remote proceedings and availability. So, according to you, is this a sustainable and a possible way to increase access to justice?
Okay. So India is a very big country. Justice has different meanings in different contexts. So let me put it this way, that yes, it was unfortunate. In the pandemic, we saw so many legal professionals, advocates, some of our own, my fellow company secretaries, facing financial issues. Work was not really flowing in. So there was some tough times that we were in. However, there was a silver lining too. What was that? A judicial system of our country, the judicial system of our country finally caught up with the demands of long pending use of technology. If you see, Ministry of Corporate Affairs, we started in 2006, the corporate affairs filing. Income tax portal started with the technology, but then the biggest load is in the judicial system, and we did not really adapt to the technology, which in 2020 we started, we took the baby steps. The case documents were filed online, were available or accessible online. The proceedings were made easy, whether it be an advocate, company secretary in practice, or any other professional, or even the public at large, could have attended to the hearings easily. The travel time, the travel cost of the litigants, the parties, was saved, and which is, let me tell you, which is one of the significant contributors to the costly litigation process in India. That obviously drive down those kind of expenses, and things became more transparent. Now the court proceedings are being webcasted live. People see what's happening. Clients get to see exactly the problems that professionals like us face. So yes, it was a very good step, and I'll not be surprised if the same becomes the new normal post-pandemic, that we see judiciary and legal professionals adapting the technology, and I'm sure this will aid to the India's rankings when it comes to the justice delivery. I really hope so.
Thank you, Rahul. Thank you once again for answering that question for us. Now we would like to know, like, how would you rate the current legal system's drive towards encouraging access to justice? Like, do you think there is a tangible movement in closing the justice gap?
Okay. I would like to, I mean, it's a very complex question. So I would like to start with a quote by a great scholar, William E. Gladstone, who said, "Justice delayed is justice denied." And in so many cases, we have seen that. Our legal system is marred with unjustified delays, complexities which cannot be understood by the maximum of the litigants. The time gap between the gap of filing the complaint and date of passing the final judgment can even surpass a generation gap. So this is the ailing judicial system that presently we are in. However, as I was just referring to technology, post-pandemic, we started with the baby steps. I think technology can be the game changer for improving the justice system or justice delivery in our country. We need to bring in a time-bound judicial process, replacing the colonial laws, and that's very important. And I think the steps have already been taken by the present government in this regard. And the law should be replaced in such a way that it strikes a chord with the current and future generation, bringing in delegated legislations, something what the government successfully managed to do in the case of, I quote a few, Companies Act 2013, pharma, with a lot of delegated powers to Reserve Bank of India, and SEBI laws, a lot of powers are delegated to stock exchanges. Creation of special courts can be looked at to help deal with the technical subjects where judicial system or judiciary may not be competent to take all kind of cases in the lower courts. And also specialized tribunals like National Company Law Tribunal, very fine example of how to specialize and decentralize and declutter the corporate law related matters. And the same process, same setup can be looked into in various other cases or specialized areas of law to ensure that there is a smoother delivery of justice to all the litigants.
Amazingly portrayed, Rahul. Thank you so much. Now, for the second last question of the session, we would like to know that in the era of legal technology, what are the most commonly used tools for you?
All right. So you brought me to, again, my favorite topic, which is technology. And when it combines with law, it is lethal, let me tell you. So in today's era, we legal professionals need a tailor-made practice management software. That's the first requirement that professionals like advocates, company secretaries, and legal consultants, advisors need to ensure that right from taking a brief relating to a case to filing of petitions, applications, documents with courts or tribunals, to even getting their fees from the client in a time-bound manner, everything should be properly tracked, and there could be an MIS also that could be generated to understand where is the gap in the justice delivery from our end. So we are very much right in saying that courts or tribunals are delaying the justice. Sometimes the problem could be at our end as well. We are taking a lot of dates, a lot of adjournments. Sometimes in some cases, maybe because we are not prepared thoroughly, how that can be avoided by using a proper compliance management software, which gives you reminders, prompts you with some kind of impetus, legal impetus as well. If you can really input those details by doing a little bit of research prior to using that software or developing that software. Yes, this is not a norm in our legal world, but given the dynamism of the legal industry, the evolution that's happening. I think if we do not adopt the technology and bring in more robust processes into legal system, I think we will be outdated.
Thank you so much, Rahul. Now we are at the very end of the session. So the last question, last but not the least, the question will be that we know time is money in any profession, and in legal, it's most of all. So how do you ensure to make the best of your time as a lawyer?
I'm a corporate law professional. I'm a proud company secretary and a corporate legal advisor. Quality of advice or documentation that we provide to client is important, and equally important is timely delivery of work. Keeping in this in mind, we started our journey of making a technology-oriented firm, making RANJ a technology-oriented firm way back in the year 2012, when probably people didn't even think in those lines in many of the cases. The idea was to weed out human intervention in processes, which ideally can be automated, develop a practice management software, and in 2020, I'm telling you, after a gap of almost 8 years, the pandemic aided our aspirations. So we were developing the software for all these years, testing it, trying to reduce the gaps or trying to reduce the bugs in the software. And finally, when the pandemic came, we had to do it in a more rigorous manner. We could achieve 100% digital office containing for every kind of assignment, SOPs, checklists, template, all the documents that come from the client, what we prepare, what ultimately gets signed and filed with the tribunals or courts or any other regulators, be it trademark, registry, or regional directorate. All this is available right at the click of the button in a mobile app at any part of the day or night to us. And this is what we could really say time is money. And yes, this kind of activities, technology, when we adopt, I think it saves a lot of time, money for the firms like us. And not only that, we benefited from it. Some of our clients also started approaching us for compliance automation softwares and asking us to implement in their companies, in their firms. And we saw it as another emerging area of practice. A new horizon has started for us, and we started helping corporates to set up legal compliance automation by providing a software or a tool to track their agreements, trademarks, their compliance with the Ministry of Corporate Affairs, Reserve Bank of India, under FEMA, or for that matter, the cases related to NCLT or other codes. So we try to put up a comprehensive legal compliance tool and which provided them a 360-degree view of how they are in terms of having good corporate governance in their companies. And I think with that, I would like to say a big thank you to LexTalk for giving this opportunity to me to provide my view, my side of the story after this of the LexTalk Global Awards. Thank you so much. And I really would like to express sincere gratitude to the entire gamut of professionals who helped me in this process from the LexTalk team. Thank you so much.
It's our pleasure, Rahul, and thank you so much for sharing such great insights with us. We look forward to having a chat with you again in the future on some trending topic in the international legal world. And for our viewers, if you like this chat with CS Rahul Jain, please like and share this video and also subscribe to Clickaway Creators YouTube channel to appreciate what we do. And we have more coming up from the legal space for you all. This is Raima from LexTalk World.